They're over your head.
Gotcha.
You see, you're scared now. You're going to be scared later. I'm glad you reacted that way.
6 months is real time. 6 months sounds small, but in court it's serious time. Judges say it early to test awareness. That moment of fear, that's the reality check before a plea.
Because it is a scary thing. 6 months in jail.
Yeah, I don't want to spend 6 months in jail.
Figure it out. We will go on the record in the matters. 24 TR 718, 24 TR 719, 727, and 922, 23 CF 165, 24 CF 168, 24 CF 240. State of Wisconsin versus Tina Sally. The state appears through District Attorney Kevin Schmidt in person. Ms. Sally appears in person with her counsel, Joseph Rosenthal. We're set today in these matters for pleas and sentencings. Mr. Rosenthal, can you please update the court as to the agreement that has been reached?
Yes, Your Honor, thank you. My client would enter a plea of guilty to an amended count 1 simple possession in 23 CF 165. Counts 2 through 5 would be
dismissed doesn't disappear. Dismissed and read in means not off the hook. Those charges still count at sentencing. No conviction, but no forgetting either.
Dismissed and read in 24 CF 168. My client would enter a guilty plea to count 2, felony bail jumping. Counts 1 and 3 would be dismissed and read in. 24 CF 240 would be dismissed and read in its entirety. And I believe there is an agreement to dismiss the traffic citations. And both sides would be free to argue. I'm sorry.
Free to argue. And Mr. Schmidt, I'm going to guess that, and just correct me if I'm wrong, the reason for the public interest for the amendment from possession with intent methamphetamine down to simple possession of methamphetamine is simply because Ms. Sally was at her place of employment and offered someone else the paraphernalia with the methamphetamine in it to take what I would describe as a hit or to use it. And so that's why it's being amended to simple possession.
If the court wants to know the public interest on it, as the court recalls from the PC statement, also in the police report, this was actually referred as simple possession by St. Croix Tribal. DA Renicky charged it as a possession with intent or delivery. He's technically right. That does constitute delivery for the same reason that a bunch of kids passing around a joint in a school circle, like from that 70s show, that would be delivery as well under Wisconsin law. All laws are overly inclusive.
The law doesn't blink. This prosecutor nails it. In Wisconsin, even passing a joint is delivery. Black and white law crashing into real-life gray.
For underly inclusive, therefore it's up to the judgment of people like myself and you, Judge, and Mr. Rosenthal to figure out, when the laws are overly or underly inclusive, what to do there. There's a situation where she just offered someone drugs. They took it for peer pressure reasons. They didn't use it. They reported it to their supervisor. No money exchanged hands. I don't have any information. Tina's, dealing drugs anywheres. So that's the reason why.
All right. Thank you.
And also, Judge, the quantity was like infinitesimally small. I don't even think it was like like 1/10 of a gram. The lab results said like 0.07. So it's just in terms of quantity,
it was very small. The officer wrote in their report it was too small for them to even measure on their scale.
All right. Okay. Thank you. Satisfies the court. Formal motion to amend count 1 and 23 CF 165 to simple possession and I felony.
So made.
Granted. All right, Miss Sally, that's the agreement that you've reached with the state. Is that true?
Yes, ma'am.
I have in front of me 2 plea questionnaires, waiver of rights forms. They're identical, except for the charge that you're pleading guilty to and the case numbers. Did your attorney go over, and the maximum penalties, they're different too, but as to what those documents state and the form itself, they're identical. Did your attorney go over this form with you thoroughly?
Yes, ma'am.
Did he essentially go over it with you word for word?
Yes, ma'am.
And did you sign both of these documents?
Yes, ma'am.
And do you understand them completely?
Yes, ma'am.
And if you didn't understand something, did you ask him to explain it?
Yes, ma'am.
And he did so?
Yes, ma'am.
So you understand everything in these documents?
I do, ma'am.
All right. Now, you were pleading guilty to 1 count of simple possession of methamphetamine and 1 count of felony bail jumping. You're 49 years old. You have 10 years of schooling. You can read.
This is legal protection, education, understanding, not small talk. This is the colloquy built to stop future claims of confusion. It's all on record.
Right? And you understand the English language. Is that all correct?
Yes, ma'am.
You do not have a high school diploma or equivalent. However, like I said, you can understand everything that's going on, right?
Yes, ma'am.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt as to these 2 charges?
Yes, ma'am.
Did your attorney go over with you the maximum possible penalty you're facing?
Yes, ma'am.
You are not receiving treatment for mental illness or disorder, and you've not had any drugs, alcohol, or medications in the last 24 hours. Is that correct?
Yes, ma'am.
Because you're charged with crimes, you are entitled to constitutional rights, and those rights are listed on those documents. Next to the rights is a box, and each of those boxes is checked. That tells me your attorney went over those rights with you. You understand those rights, and you understand that you're giving up those rights by pleading guilty. Is that all true?
Yes, ma'am.
Do you need me to go over those rights with you in any more detail?
No, ma'am.
So you understand those rights completely.
Yes, ma'am, I do.
You understand that if you're not a citizen of the United States, your pleas could result in your deportation.
Yes, ma'am.
You understand that you're pleading guilty to felonies. As such, you will no longer be able to use or possess a firearm for life.
Yes, ma'am.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, ma'am.
You understand that the state would have to prove in 24 CF 168, the felony bail jump, that on or around July 14, 2024, in Burnett County, Wisconsin, having been charged with a felony in Polk County case number 22 CF 171, and having been released from custody, you intentionally failed to comply with the terms of your bond by possessing illegal drugs, substances, or paraphernalia, and you did not have any valid prescription to possess any of the items you had. Do you understand what the state would have to?
Every yes locks in. Each yes, ma'am matters. The court is stacking proof of awareness. Polite on the surface, permanent underneath.
Yes, ma'am.
Do you understand the maximum possible penalty could be up to a $10,000 fine, 6 years of incarceration, or both?
Yes, ma'am.
You understand that in 23 CF 165, count 1, amended to simple possession of methamphetamine and I felony, the state would have to prove on or around September 9th, 2023, you possessed a substance. The substance was a controlled substance, methamphetamine, and that you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes, ma'am, I do.
Do you understand that upon conviction, you face up to $10,000 fine, 3.5 years of incarceration, or both?
Yes, ma'am.
You further understand that there is an agreement here for what's called free to argue. Do you understand that means that each side is free to argue any sentence recommendation to the court that they wish and they desire? Do you understand that?
Yes, ma'am.
Do you understand I'm not bound to follow any of those arguments? I don't have to follow the states. I don't have to listen to the defenses. I must listen, but I don't have to follow, and that I'm free in my own discretion to sentence you to what I believe would be a fair and just sentence for these cases in my discretion only. Do you understand that?
Yes, ma'am.
And that could be the maximum possible penalties. Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter guilty pleas?
Yes, ma'am.
Do you have any questions for the court or your attorney before I proceed?
No, ma'am.
Did you go over the criminal complaints in both of those cases with your attorney?
Yes, ma'am.
In particular, there's sections called the probable cause sections that basically say what happened those days and why you were charged with the crimes. For the most part, are those facts accurate?
Yes, ma'am.
Are you admitting here today that on or around September 9th, 2023, you in fact did possess methamphetamine
Yes, ma'am.
and you knew it was methamphetamine?
Yes, ma'am.
Are you admitting here today that on or around July 14th, 2024, that you knew you were on felony bail felony bail with certain conditions and bond in Polk County on a felony case, and that you intentionally violated that bond and those conditions by possessing illegal substances?
Yes, ma'am.
Mr. Rosenthal, may the court use the probable cause sections along with the statements made by your client to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these two charges?
No, ma'am.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing here today
Yes, ma'am.
and voluntarily.
Yes, ma'am.
Has your attorney represented you competently?
Yes, ma'am.
Has he answered all of your questions?
Yes, ma'am.
Has he looked at these matters thoroughly?
Yes, ma'am.
Has he discussed with you any potential for legal defenses, or has he said you have no defenses or little defenses in this case?
What, I mean,
The question is whether I've advised you
Oh,
on whether there's any
yes, ma'am.
defenses or not.
yes, ma'am.
He talked to you about whether or not you have
Yeah.
any defenses?
Yes, ma'am.
And what, if you go to trial, what could happen?
Yes, ma'am.
Are you satisfied with his services?
Yes, ma'am, I am.
Any questions for the court or your attorney before I proceed?
No, ma'am.
As to 23 CF 165, count 1, simple possession of methamphetamine, and I, felony, how do you wish to plead?
Guilty.
As to 24 CF 168, count 2, felony bail jumping, and H, felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily.
The final seal. Knowingly, intelligently, voluntarily. 3 words that lock the plea. After this, reversing course is uphill. Routine language. Final impact.
Voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find that you understand and that there is a factual basis. I will dismiss and read in all other counts and cases and open matters. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Sure. Checking one thing. Yep. What I would ask the court to do